Hello everyone, I am Jaydeep P. Shah, working as an assistant professor in KKWIEE&R Nasik. Today I am going to discuss about fundamentals of patent. Learning objectives. After this session, students will be able to understand what is IPR, what is patent, types of patents, patent application procedure. Let's start with intellectual property rights. Intellectual property rights are the rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. So there are two types, industrial property and copyright. In industrial property, there are again four categories: patent, trademark, industrial design, and trade secrets. In this session, we will be discussing only on patents. What is patent? Patent is the exclusive right granted by a government to an inventor to manufacture, use, or sell an invention for a certain number of years. Today is the era not only the survival of the fittest, but also the survival of faster and stronger. The latter two in marketing lexicon are termed as competitive advantage. US Patent and Trademark Office. A patent is an official document granting property rights to the inventor or to the assignee. An inventor is always a person, never a company or any other type of organization. An assignee, the owner or holder of a patent, can be a person or a company or an organization or a country. The term of a patent is generally 20 years from the date of application in the United States and in many countries, providing that maintenance fees are paid. A patent granted by the USPTO is effective only in the United States, its territories, and possessions. A patent grant the right to exclude others from making, using, offering for sale, selling, or importing the invention. A patent does not grant the right to engage in any of those activities. The assignee, the patent owner, may license the patent to another party. Types of patents. Utility patents. 20 years from filing. This is an primary type of US patent that is awarded. Examples: chemical, mechanical, and electrical segment. Design patents. 14 years from issue. Awarded for a new, original, and ornamental design for a manufactured article. Plant patents. 20 years from filing for the invention or discovery and reproduction of any distinct and new variety of plants. Reissue patents. These are granted when any substantial error or errors are determined to exist in the original patent. Benefits of patent registration. First, it keeps the adversaries at bay, as you have all the rights possessed to yourself. It improves your business interest, as it enables the patent holder to accredit a premium for the invention. Certain patents are just like other kinds of property, hence it is reasonable to license or sell them. It makes It's simpler to raise capital for your business if you are ready to sell or license the patent that you possesses. The credibility of the originator will go up after patent registration is done. Essentials that determines if your invention is patentable or not. There are four main points. Novelty. The primary qualification is that the invention should be novel and not be a part of any prior art. Second, inventiveness. The product should not be apparent. It should not be of such nature that a layperson can come up with the same product or invention by combining the instructions of different documents that are available to the public. Third, inventiveness. It should have some technological advancement and innovative action that adds to the existing knowledge, which makes the invention not visible to any person skilled in the art. Utility application. Manufactured, applied in at least one field of activity. Reproduce with the some features, properties as many times as necessary. Recreated with the same characteristics, properties as numerous times as necessary. Let's discuss the procedure. Different steps to file a patent. First, documentation of new invention, patent search to validate invention, filing for a patent in patent office, publication of the application, then examination of the applications. Many people, they are not considering this point, means that is their mistake. Then grant of patent and periodic renewal. Let's discuss it in detail. Patent application. First, provisional application. Within 12 months you have to submit complete specification. Then you are going to request for the examination. Again, there are two options: deemed to be withdraw, then response to FER, hearing, order for grant, order for reuse, appeal against the order, reply for objections in hearing, publication of grant patent number allotted. Patent law in India. The present Patent Act 1970 came into force in the year 1972, amending the consolidating the existing law relating to patents in India. The Patent Act 1970 was again amended by the Patents Act 2005, wherein product patents was extended to all fields of technology, including food, drugs, chemicals, and microorganisms. After the amendments, the provisions relating to exclusive marketing rights have been repealed, and a provision for enabling grant of compulsory license has been introduced. Procedure for a grant of a patent in India. After filing the application for a grant of patent, a request for examination is required to be made for examination of application by the Indian Patent Office. After the first examination report is issued, the applicant is given an opportunity to meet the objection raised in the report. The applicant has to comply with the requirements within 12 months from the issuance of the first examination report. Then, if the requirements of the first examination report are not complied with within the prescribed period of 12 months, then application is treated to have been abandoned by the applicant. After the removal of objections, and compliance of requirements, the patent is granted and notified in the Patent Office Journal. Filing the patent application in India. First, application for grant of patent. So there are different forms. These 5 forms are very important. Second, provisional or complete specification, form number 2. Then form number 3. It is for statement and undertaking under section 8. Declaration as to inventorship, form number 5. Form submitted only by startup and small entities, form number 28. So generally patent grant takes 4 to 8 years, and if you are a startup and by the means of startup you are filing a patent, it will take hardly 1 or 2 years. In April 26th April, recently we all celebrated World Intellectual Property Day. The theme was Innovate for a Green Future. So on this day, many organizations arranged many sessions, webinars, and they guided thousands of people interested in IPR segment. PCT, the International Patent System. The Patent Cooperation Treaty assists applicants in seeking patent protection internationally for their inventions, helps patent offices with their patent granting decisions, and facilitates public access to a wealth of technical information relating to those inventions. By filing one international patent application under the PCT, applicants can simultaneously seek protection for an invention in a large number of countries. What do I need to know about IPR? Intellectual property rights are governed by WIPO, the World Intellectual Property Organization. WIPO harmonizes global policy and protects IPR across borders. As a researcher, you rely on the published work to create a new hypothesis or to support findings. You should therefore ensure that you do not infringe the copyright of the owner or author of the published work. Example, images, figures, data, extracts, etc. What is WIPO? World Intellectual Property Organization is the global forum for intellectual property services, policies, information, and cooperation. They are a self-funding agency of United Nations with 193 member states. Their mission is to lead the development of a balanced and effective international IP system that enables innovation and creativity for the benefit for all. Our mandate, governing bodies and procedures are set out in the WIPO Convention, which established WIPO in 1967. How do you decide whether to publish or patent? Check your local IPR laws. IPR laws vary between countries and regions. In many countries, a patent will not be granted for an idea that has already been published. So you should patent first and then publish. Researchers therefore are advised to file a patent application before publishing a paper of their invention. Discussing an invention in public is what is known as public disclosure. These are my references. Thank you very much for your attention.